Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to learn C.P.C. Case Law on Specific Relief Act, Section 16 particularly. Agreement to sell. Very, very important. Quite often, as advocates, you will be coming across the so-called institution of suit for failure to perform the part as per the agreement to sell. One such case, that is Janardhan Das and others. Janardhan Das and others versus Durga Prasad Agarwall and others. This is Civil Appeal number 613 by 2017. Decided on 26/9/2024 by 3 judges bench of the Honorable Supreme Court of India. Justice Vikramnath, Justice Pankaj Mittal and Justice Prasanna B. Varale. They held that the plaintiff has to secure the consent of all the shareholders before going for the agreement to sell, and he cannot rely solely on only one particular dependent. In this case, what happened is, on behalf of the others, seven others, D1 has signed the agreement stating that he would call or he would bring or he would procure the D2 to D8 on the day of execution of the registered agreement. But D6 to D8, who are the sisters, they are not willing. They did not come for the execution. That's why this trouble has come. Karanam Adi. Let us go into the facts of the case. So, on 6/6/1993, there was an agreement to sell between Janardhan Das and Durga Prasad Agarwall and others regarding particular property in Baripada area. Right. So, the property was jointly owned by actually 2 brothers and 3 sisters, 5. And there are co-owners, co-partners antam kada, vallu kuda unnaru. Total 8 members. Actually, this particular property is owned by 5, 2 brothers and 3 sisters. The agreement was executed on 6/6/1993 by defendant 1, that is Durga Prasad Agarwall. And this Durga Prasad promised Janardhan Das that he will secure the presence of the others on the date of execution, that is after 3 months. But this man did not show any interest to call his sisters. Moreover, Janardhan Das also simply believed this Durga Prasad and he kept quiet. He did not make any efforts to approach them, to console them, to make them come to the registration office for the registration. And he relied on the D1 as well as another co-owner, Shyam Sundar or some name is there. Soumendra Kumar, co-owner. He believed them, but in the meanwhile, what happened is, this Durga Prasad Agarwall and his sisters, they wanted to execute another document in favor of, they wanted to sell it to other persons. So having come to know about this, he instituted a civil suit. So according to section 16, he filed a civil suit. He sought to enforce the agreement to sell, right, as they executed the sale deed in favor of Janardhan Das. But trial court said there are other partners, other persons who are joint owners. So if they do not concur, if they do not agree, how can this agreement be valid? No. Trial court dismissed. Then this man approached the Honorable High Court of Bihar. High Court also held the same thing but modified. So I say, simply to say, High Court has given an order for execution of the sale deed. So this Durga Prasad Agarwal and others, they have to perform their obligation. That means they have to register the land. This is the direction given by the High Court. Now, matter came to the Supreme Court. Supreme Court struck down the orders of the High Court. 2 points. Number 1, whenever you wanted to purchase some property from X or Y, you have to go through the encumbrance certificate. You have to know how many owners are there. You have to know how many joint owners are there. You have to convince all of them. You have to get agreement for all of them, not from one. So he has to convince the others. He has to secure the others. That was not done. Second point, as regards the readiness and willingness. Willingness, yes, I am ready. I am willing to get the property registered in my name. How do you prove the readiness? That's why time and again I have been telling you, please deposit the money in bank account and show that, yes, I am ready with the money, which this man has not shown. The Supreme Court held that his part of readiness and willingness is doubtful. He is not ready. So therefore, the orders of the trial court are 100% correct, and the High Court has committed an error in allowing him for the execution. Appeal is allowed. Orders of the High Court are set aside. So, Honorable Supreme Court of India placed reliance on a very important case, that is V.N. Krishnamurthy versus A.M. Krishnamurthy 2023. So, please remember, it is your responsibility to get the execution done and attested by all the owners of the property. That is very, very important. Right, with this I am concluding. Thank you very much.